Good afternoon. My name is Yvonne Williams-Voss, and I would like to welcome you to the Sutherland Webcast examining the impact of the Yates Memo, the FCPA Unit Pilot Program, and recent legal decisions. I'm joined today by three Sutherland attorneys, Peter Anderson, Jeff Bialos, and Olga Greenberg, for a roundtable discussion that I will be moderating. Following recent regulatory announcements and legal decisions, internal investigations are increasingly becoming more complicated to navigate. Our roundtable discussion will focus on the impact of judicial and government pronouncements as we examine what is the current reality for corporate executives and their companies. If you would like to receive CLE credit for this webinar, please download the CLE sign-in sheet and the evaluation form from your viewing console and follow the instructions for submission. About halfway through the presentation, I will give a keyword which you'll need to complete that form. If you have any questions during the webcast, please submit them via the Ask a Question text box in your viewing console. So to kick it off, as we look at 2016, the first question I want to propose to our panel is what thus far distinguishes internal investigations in 2016 to what we've seen in prior years? Peter?
Well, I think in 2016 what we've seen is an increased focus on individuals. The Gilman decision coming out of the Second Circuit is a strong example of that. In Gilman, the Second Circuit indicated that while executives were placed in a tough position between choosing their employment and incrimination, they had no choice but to comply with a request for an interview in an internal investigation, that they were not immunized in any respect from the collateral consequences, and it really left the company with no practical option, and that's the Second Circuit's language, no practical option other than to terminate their employment when they refused what they called a reasonable interview request. The Second Circuit went on to say requests for interviews were per se reasonable.
And Peter, in that case, or in that instance, there had been an ongoing investigation by the Attorney General that in part had prompted these individuals not to want to cooperate, correct?
That is correct.
But that was not considered by the court to be state action.
The court, the Second Circuit again rejected that argument and said the company wasn't a state actor. They had the right to require participation. And the court indicated that it would be incompatible with corporate governance and modern regulation not to investigate and not to request the interviews. The court said the company had a duty, and they used that language, duty, to its shareholders to investigate any potential criminal conduct. And more importantly, they said there was a duty on the part of the officers to disclose what they knew about it. There is no Fifth Amendment rights unless they chose to assert them, and in doing so, rightfully would lose their jobs.
And Olga, maybe you could talk about what has prompted this increased focus on individuals that we're seeing this year.
Sure. And if we can go to slide number 3, and I can address the Yates Memorandum that had recently come out of the Justice Department in September of 2015. The general message that we are hearing now from the Justice Department is not entirely novel. We've heard for years through various pronouncements in the form of the Holder memo, the Thompson and the Phillip memos over the past 17 or so years that corporations act through individuals, that the Justice Department will hold individuals accountable for corporate fraud. And just because the department pursues a corporation, that will not absolve any individual liability, and the Justice Department will continue to pursue individuals in appropriate cases. What has changed recently with the Yates memo, however, and Sally Yates, the Deputy Attorney General of the U.S., is a more aggressive view that builds on that prior message. And what we tend to think that it's more of a directive to the corporate world that the department is serious about pursuing individuals, and the memo goes farther than any prior pronouncement in saying, in very few words, through a very direct message, that in order for the company to receive any cooperation credit, to mitigate any possible sanction against the company must identify all individuals involved in the wrongdoing and provide the department all relevant facts about those individuals and about the alleged criminal activity. And if the company doesn't properly investigate and doesn't provide that information, including, again, information about the individuals that may ultimately be held responsible, the company will not be eligible for any cooperation credit. So it's basically an all-or-nothing proposition that puts potentially the individuals who may have been involved in the conduct at issue and the corporation at odds. That will be the focus of our discussion today.
Jeff, are you seeing a similar increased focus on individuals in FCPA actions?
Sure, and just briefly by way of background, I at Sutherland work on FCPA, export control, and procurement internal investigations, and I spent number of years in government service, and while at the State Department was involved in the final throes of the negotiation of the OECD Anti-Bribery Convention, and in my capacity as Deputy Undersecretary of Defense, we focused on these anti-bribery industry issues in the defense industry, where there were considerable issues in this regard. But to answer your question, yes, I think, again, just like Yates was an extension of things before it, the whole evolution of Yates can be seen in the FCPA context, Foreign Corrupt Practice Act context. There was a Lane Christensen case several years ago with significant improper payments, over $1 million in payments, and justice didn't pursue criminal charges despite what they found to be pervasive criminal conduct because, among other things, of exemplary cooperation and reports on the internal investigation. Employees were terminated. There have been statements by the Justice Department officials over several years in the FCPA context also that said, in whether to give credit to a company for a voluntary disclosure of a violation, they will consider whether, quote, the company's exposed and provided evidence against the culpable individuals. So I think these already have raised the bar in the FCPA context and, put companies in a challenging position where, euphemistically, it's when and whether you throw your executives under the bus, so to speak, but companies are put in a challenging position by the confluence of legal and regulatory issues. On the one hand, you have auditors who are focused on conduct. You may have, if you're a public company, you have reporting obligations, and now comes the Yates Memo, and we'll talk about the FCPA pilot program in a minute, and all of these things together really put pressure on companies to do full investigation, to do full disclosures, including of their executives' conduct.
Yeah, the Yates Memo indicates that you can't decline to investigate. You must investigate. So that's a given. And I think the second thing that the Yates Memo makes very, very clear, as Olga indicated, was that now you have to give names. You have to give individuals, and you have to detail where the individuals were involved in the criminal conduct. I don't think there's any question about that. And if you're not giving names and you're not detailing the criminal conduct in the FCPA world, you're not going to get credit. It's just that simple.
Jeff, you mentioned the FCPA pilot program. Can you give a brief overview of what that is and what you're seeing?
Sure, and I think you now switch to the next page on this. Again, the pilot program, is not startlingly new. It confirms and memorializes a number of trends in FCPA practice. On on the view of individual culpability, the degree of investigative thoroughness and cooperation, and when you receive credit for voluntary disclosures, because that's a central issue in FCPA enforcement. When do you voluntarily disclose a violation, and what credit do you get for doing that? The trends that, if you will, that the pilot program have to be understood in the context of, first of all, Justice has been extensively investigating and really put priority on FCPA violations for a number of years, and the dominant trend is high fines. Over a 4, 5, 6-year period, the fines have been very large and very sizable, and there have been numerous of them. Second, there's really been an increased focus on conducting full investigations, driven in part by outside audit firms, which in the post-Enron world have demanded a degree of investigative thoroughness of big and small firms alike that have required very thorough internal investigations. And there's also a trend, I would say, toward increased risk aversion, if you will, by boards of directors as they focus on prudent governance and oversight and how to meet their fiduciary obligations. So the level of thoroughness is higher. And finally, the pilot program has to be understood in the context of, among FCPA questioners, the question over the years has been, does Justice really give you credit? Do you really get a discount for making a voluntary disclosure? Because, again, you have a choice. And there have been a couple of recent cases in recent years where they have said yes. The Hewlett-Packard case in 2014 and the Alcoa case gave discounts off the bottom end of the sentencing guidelines. So briefly what the pilot program does is it really memorializes trends. First of all, it says that to get credit under this pilot program, the disclosure has to be truly voluntary before there's an imminent threat of government investigation, timely, and it has to disclose all the facts, including relevant facts about the individuals. Second, it has to be a full cooperation, again, including disclosure on a timely basis of all facts, including the facts relating to the involvement in the criminal activity of the firm's officers, employees, and agents. So that has to be done to get credit, as Peter said before. And finally, there has to be complete remediation. Now, if and when you do all those things, you can get up to a 50% reduction in the fine from the bottom end of the sentencing guidelines. Again, that's up to, so the government has discretion. Interestingly, it also says that even if you don't disclose, but if it comes out that there was a violation and you subsequently cooperate, you can get up to a 25% reduction. So, again, I think what these things do, in my view, is shape and frame the decisions companies make when they decide whether to voluntarily disclose it, if they have that choice. And again, public companies may not have much of that choice because, in some cases, material information about the company has to be disclosed under the security laws. But private firms do have that, and the challenge is to make an informed choice and how all this environment affects it.
Olga, you've been doing some work outside of the United States for foreign companies. Are you seeing how those companies are affected by these trends towards a focus on individuals and increased prosecution?
Sure. And just as a way of background, both Peter and I have significant experience conducting internal investigations and corporate investigations, and in recent months I've had the opportunity to work abroad. And what we're seeing, particularly with Latin American clients that have operations in the U.S. and are otherwise subject to U.S. law, is this increased scrutiny and increased pressure that they're feeling. So, for instance, if they, through their foreign operations or in their foreign operations, discover some improprieties, perhaps bribery or some other illegal activities, one of the first questions that comes to mind when they're figuring out what it is that they need to do to address that conduct is what implication that may have in the United States. Which regulators would be involved, with the Justice Department be interested in looking at it? So whereas before, it didn't enter into their decision matrix very early on in the scope of their inquiry. Right now, it's one of the first questions that these companies face and one of the first issues that they encounter. How do they deal? Do they need to disclose to the authorities in the United States? What implications does that have for their foreign affiliates and their foreign subsidiaries? And what implication does that have for their executives and officers who are resident in those other countries? And for many of Latin American countries, these are not the questions that they've had to answer previously. They have not traditionally had the same anti-corruption laws that the United States has. It's more of a recent development, but it's certainly now very much on their radar, and certainly one of the very first issues that they begin to analyze when they discover any of the activities that we're talking about today.
And I believe Jeff mentioned briefly in discussing the FCPA pilot program that an important consideration now is whether or not to cooperate in government investigations. And I know that both the Yates memo and some other government pronouncements, we've seen a continued emphasis on the importance of cooperation with the government. In the past, cooperation credit has been a significant motivator for counsel and companies, both in the representation of corporations and also in the representation of individual executives and employees to cooperate and to work with the DOJ and other regulators. After the Yates memo, it appears that to receive consideration for cooperation, the company must completely disclose all relevant facts, and the all relevant facts language is really what we're seeing tossed around a lot in various articles and discussions about the Yates Memorandum. And my question now for the panel to discuss is, with this all or nothing approach, what is the value of cooperation credit in 2016? Olga, do you want to start us off?
Sure. And, the companies are going to often find themselves cornered in this situation. So in order to receive any cooperation credit or any mitigation to a potential sanction, you have to cooperate. And you have to decide very, very early on in your investigation, as soon as you find out that you may have an issue, based on very limited or incomplete information of how you're going to cooperate with the government. And ultimately, the decision down the road may be that was not the right decision. But nonetheless, being put in this catch-22 situation, you have to decide that early on. What kind of credit you're going to get ultimately, of course, you're not going to know, and the government is going to have the benefit of hindsight after the investigation is complete, whether you provided adequate information, whether you have conducted a complete investigation, and and of course, the amount of cooperation is completely within the discretion of the government. So while it just puts companies in a very difficult situation because, again, the decision has to be made very early on based on very limited and incomplete information.
Do you think, Olga, that companies get less credit if they're reporting to the government, let's say to the U.S. Attorney's Office, hey, look, we're conducting this investigation, but we weren't able to talk to Joe Smith and Tom Jones and Bill Williams because they all asserted their Fifth Amendment privilege and declined to be interviewed? I mean, do you think that, bottom line, that impacts what credit the company eventually gets?
Sure, because at the end of the day, the Justice Department, with the benefit of hindsight, will evaluate how assertive you were in getting that information, what avenues did you try, who did you talk to, what attempts did you make, did that person give you a pushback, and you nonetheless came back multiple times and requested to speak with that person. So I think they're going to evaluate how stringent your attempts were to obtain that information. Now, if you can't get if you can't get an interview with somebody, you can't get an interview with somebody. And in post-Yates memo pronouncements, senior department officials have acknowledged that fact, that, sometimes you just don't have control over the people who possess the information or the documents or sources of information that you otherwise would need to get a full and complete picture. And the department, I think, acknowledged that. But again, I think that the department will nonetheless evaluate what attempts and what pressures you put on people in order to be able to have a complete picture of what happened, as opposed to sitting back and saying, well, Tom Jones said he's not going to talk to me, so I guess we're not going to talk to Tom Jones.
Yeah, I haven't had the circumstance yet where there's been, coming back from the U.S. Attorney's Office, there's been an indication, we recognize you tried, but the truth of the matter is you didn't talk to Jones, Williams, and Smith, and so therefore you're not going to get the full credit you might otherwise have received. But I just feel like that's coming. I just feel like we're going to hear that in near term, and I think it's driven by the Yates memo more than anything else. We can tell them that look, we asked, they said no, they said they're going to assert their rights. It's been on the advice of counsel. We terminated them, and yet I still believe that it's going to pose a roadblock, I think, for a lot of companies.
Perhaps in some investigations, prior to deciding whether or not you're going to cooperate with the government investigation, there is the issue of whether or not you're even going to disclose an issue you've identified to the government. Jeff, do you want to talk about the decision on whether or not to self-disclose?
Sure, and that's a decision that comes up in many contexts. Generally under American law, disclosure is voluntary, not mandatory. It's left to the willing volunteer, so to speak. And so whether it's FCPA, export controls, procurement, other financial or other areas, the company often has a choice. Again, tempered by the fact that public companies who are subject to securities laws may have no choice but to disclose material information, and therefore they may not have that choice. But in many cases they do. I would say one thing I want to say, following on the last discussion, is that before you even get to whether you disclose it, today the cumulative effect of Yates, these various decisions, and what's gone on, and how the government's evolved, and how accounting firms have evolved with their forensic shops and the pressure on companies to do thorough investigations, I think you have no choice today but to do a pretty thorough investigation at the get-go if you want to even consider disclosing and getting credit. So before you even make that choice, you face that fundamental question: are you going to do a real investigation where you might get credit later if you decide to disclose or not? And that's it's going to be a tough call. But what this decision analysis does for you is this is a sort of form of decision analysis that takes it and it uses it as a decision aid. And I've found over the years that clients have found this helpful to think through the choice of whether to disclose or not. So when you look at this chart with the lines on it, you'll see on the left what's called a decision node, that big black box. The top choice is, you've investigated, you found there's a violation, and you've decided, the company's going to decide, well, maybe I won't disclose it. And if you don't disclose it, there are two possibilities. One is that nobody ever finds out about it because it doesn't come to light. And that's the top line, and we've assigned arbitrarily, just for illustration purposes, a 0.8% probability of that. Now, it may be that it does come to light. When could it come to light? In real life, through a disgruntled employee, through other people who know about it, who disclose it to the government, maybe through an ancillary foreign government investigation. And if it does come to light, what we've done here is assume that the full fine would be paid for, right? In other words, the full, in this case, we arbitrarily put $2 million in. That's kind of low in FCPA world, but that's what we put in. And if you look at that, we've put an expected value on that at the bottom and said, well, that option, if you don't disclose, has an expected total value of $400,000 plus some percent of attorney's fees and expenses, because, again, you'll have to do the investigation that's internal anyway, but if you don't disclose, it's not likely you would have to incur the cost of the further government investigation. Now, the other choice, and that's on the bottom of the page, is you disclose. If you disclose, and it's a real violation of the FCPA, in all likelihood, you're going to face some adverse outcome in the way of a settlement agreement. In the top of the three choices there's a probability that maybe the government just declines to prosecute and maybe the SEC doesn't go after you, and there might be no penalty and no cost. That's not a high likelihood if it's something that's more than a de minimis FCA violation these days. On the bottom, there's the probability of a plea agreement, which meant you would plead criminally guilty, which, again, is not, when you voluntarily disclose it, one of the benefits you typically get is you would not be expected to plead to a crime. There are circumstances where it's possible, so we assign the low percent arbitrarily. The most likely outcome is some kind of a deferred prosecution if you voluntarily disclose it. And what we've done is said if it's a deferred prosecution and you voluntarily disclosed it, we've given you the benefit of that 50% discount Justice had in the pilot program. So rather than the $2 million, we say the fine is $1 million. And for the plea agreement, we say you get less of a discount if it's so serious a thing that they're still going to make you plead guilty of 1.5. If you do the math, 0.8% of the million for the deferred prosecution is $800,000. 0.1% of the 1.5 million for a plea agreement is $150,000, and that totals, when you add those outcomes, to about $950,000. So what you can see there is that the expected value of not disclosing is, and here the expected value, the lower it is, the better. Is lower if you don't disclose than if you disclose. And obviously you can play around with these variables and come up with different outcomes. But what I would, for example, we assume the probability of non-disclosure, probability of somebody finding out was low. If you change that variable, it has an impact. But really what drives it is the level of the fines. If the fines are higher than $2 million, the higher the fines, the greater the discrepancy between voluntary disclosing and not disclosing in the outcome. And so what you'll see from that is the magnitude would significantly change. The other fact not in here, of course, is the issue of the Yates memo and individual culpability and how that affects your consideration and analysis. And again, that is a factor that may drive some people to choose not to disclose, because if you have a rock star executive, the question is, what do you want to do with him? So, there may be also other prudent reasons to disclose from a governance standpoint, not here. And by the way, all these choices assume you investigate and that you remediate.
Jeff, let me ask you this, though. In the situation where you're not disclosing, is it more likely than not that you have done some investigation, but maybe you haven't done the fulsome investigation that Sally Yates' memo contemplates, that you haven't turned over every rock, that in fact you haven't interviewed all of the senior members in the C-suite, but you've done enough to know you've got a problem, and you can remediate the problem without interviewing the very high-ups?
I mean, that is one approach. The dilemma is typically when companies, when issues come to the fore, when somebody says there may be a violation, you don't know whether you can disclose it or not up front. And you don't know where you are on that until you finish your investigation. And so that's where it gets sort of challenging today, and that's the point I made at the beginning, Peter, which is I think the full impact of all of these cumulative things that pressure companies today, or the constraints on companies, lead most companies to say, I got to really do a real investigation up front because there's some chance I may want to voluntarily disclose it. That's the dilemma today. If you don't do the full investigation, and you do remediate, the odds of you getting a credit for that later is probably low. You'll get probably the full fine, maybe a monitor if you went to justice, and some other things. So that's the challenge today.
And Peter, I know a lot of your practice is spent advising individuals and executives. Before we even get to this decision analysis, many of those individuals would have had to have made the decision whether or not to cooperate in an investigation potentially. How would you advise someone there?
Well, I think a couple of things. One, I think it does depend on the size of the company. If the smaller the company, I think perhaps the greater the flexibility that you have. One of the things in looking at even at Jeff's chart, I'm always amazed that in the conduct of an internal investigation, how surprised either members of the special committee are, the audit committee, however the board-designated group is that's going to oversee the investigation, how surprised they are at who's on the list to be talked to, who's on the list to be spoken to. And, I can tell you I've had a number of occasions where I've gotten the question, is it really necessary? Is it really necessary to talk to him? What is it you think you're going to derive from talking to him that you can't find out from somebody else? And so you have that internal mindset within the company that we really don't want to push. We don't want to push that button because we may be concerned about what the answer is going to be, which is, I don't want to talk to you. You can fire me, but I choose not to be interviewed about this. And that really puts companies, especially as Jeff said, when we're dealing with a rock star, that really puts companies, boards especially, in a difficult position. But there are very few circumstances that I can think of where there's a question about my client's potential culpability or involvement in any sort of criminal wrongdoing that I'm going to let my client speak to the outside counsel who's conducting the internal investigation. There's just no upside. And it does mean that my client's likely, and if you follow the Gilman decision, should lose his position. But it's better than guaranteeing that he's going to be spending time in jail.
As a brief interruption, for those of you seeking CLE credit, your code word for today is Yates, Y-A-T-E-S. Olga, given what we've been discussing, is a conclusion from that and a takeaway that executives are just at a greater risk than they've ever been before? Olga, are you still there?
I'm here, I'm sorry. I don't think that they're at a greater risk, but I do think that they're under increased scrutiny, and that scrutiny and pressure will become very much real at the very beginning of the investigation, whereas before, when counsel for the company is conducting an investigation, the focus very much was on finding out what happened, understanding what the facts are, and then later determining if anybody should be held responsible for it. Now, the focus very much from the beginning is who is responsible, and there's now a presumption, I would say, that someone will be held accountable, and as a result, there will be a greater scrutiny, and folks will be under much more pressure, which of course curtails the investigation. It makes investigations more costly because folks are not going to be inclined to be as forthcoming as they would have been otherwise. They would not be as helpful as they were otherwise. They would just be, very cautious in their responses and the information that they're given that, there is now this cloud hanging over everybody's head when they're being interviewed or otherwise being examined, that they ultimately may have some responsibility for the corporate wrongdoing.
They did a survey that was recently published. I believe it was in the Wall Street Journal within the last couple of weeks of general counsels of companies, and to a person, he or she, it had indicated that they were increasingly unhappy with the length of time of the investigation and certainly the expense related to the investigations. And part of that is that everybody gets lawyered up. When the company is domiciled or its corporate headquarters are in a state that provides for advancement, everybody is going to go out and get their own lawyer, and you have to deal with that lawyer, even in circumstances where the corporate executive agrees to be interviewed. And so, we have increasing time and we have increasing expense associated with it.
Jeff, we've been talking a bit about the perspective from advising the executive client, but what about how do you advise a client that is a whole corporation? Does that change the perspective and the advice that we're giving them?
Sure. Again, if I put myself in the place of the board or the special committee or top management, you're in a tough place today when some allegation of wrongdoing comes up. Because again, you face an auditor who's going to push you to fully investigate, a regulator who won't give you credit unless you fully investigate under Yates and pilot programs and various other practice today before the government. And so all of that pushes you to do a full investigation and to inquire of your employees and executives. And if you have an executive who is not cooperative, I think to the Patriots and Tom Brady, and he destroyed his cell phone. He didn't give it over, and one of my reactions to that, if that was a corporate executive today, you'd be hard placed not to, terminate that employee for that kind of conduct, even if he is a rock star. And it puts the company under the cumulative effect of this thing. I think Yates is just an additional cumulative point on the scale. Puts you in a position where the company has a fiduciary obligation to its shareholders to protect the company, and I think that's the starting and ending point of this.
And if you believe that the companies or the employees in your company think that you will throw them under the bus effectively in order to get cooperation credit, when do you make the decision about whether or not to include someone as part of the interview lineup if you think that you'll lose that employee just because you interviewed them?
Or asked to interview them.
Or asked to interview them.
I think that's the really the turning point. Once you ask, you're sort of already down the road.
Right.
One question I had for Olga and Jeff is, would you take something less than an interview of the individual? Would you take an attorney proffer as to what the individual might say, or would you take a series of documents that would reflect the individual's involvement, as opposed to actually sitting down and recording what they may say in answer to your questions? Because we all know we don't really want to be the government's witness at trial, recounting what this particular executive said in response to our questions.
Well, I think that if this individual is deemed to be a key person or someone who was directly involved in the alleged wrongdoing, the expectation that the government would have is that you would request an interview and you would sit down for the interview. Now, if the person declines to do it, and, of course, there may be some action that results from that, but if the person declines to do it, going back to what I said a few minutes ago, I think the government will expect you to go back to either them or their counsel and get a proffer or get something that's second best to sitting down for an in-person interview. So do you take it as a first offer? No, you don't take it as a first offer. I think, again, the expectation is that you sit down with that person. If that person was not directly involved in the activity or, may not have personal knowledge of it, perhaps, you can resort to other means. But I think the expectation, again, would be to get the most information that you can in the best, most direct way that you can.
Yeah. I mean, Gilman almost suggests that once you ask and they decline, that they need to go. They need to go. Jeff,
right.
your thought?
Yeah. No, look, I think one of the issues, and the memo on the FCPA pilot program raises, what one has to think very careful about how to shape the scope of the investigation up front. So in the FCPA context, let's suppose, for example, it's an alleged bribe through an agent with respect to business in Peru. What's the scope? Do you go out and investigate thinking that, gee, it might have been done in 5 other countries where you don't have any specific evidence? Do you go out and do that? I think obviously all of this is going to give you cause you to take some care. And, obviously you would like to, as a corporate counsel, do it in as narrow a way as possible while fulfilling the government request. What they do say in this memo that's interesting is, look, if the investigation is about Peru, unless you have some expectation or some evidence of wrongdoing in other countries, you don't have to go out and investigate it. However, if the team that was doing the wrongdoing was in charge of all of South America, and you found wrongdoing in Peru, you would be required to investigate their activity in the other countries in South America. So it gives you a little bit more guidance than has been out there in the past on that. And again, how to shape the scope of the investigation, before you get to individuals, I think may help inform this issue.
And in shaping the investigation, I think one of the things we need to take into consideration, or you would need to take into consideration in designing your investigation, is whether you're dealing with a large company or small company and the role that the individuals are playing in the company. Again, we mentioned briefly that public companies may have different obligations given the SEC reporting requirements, but a smaller company who is really relying on a small set of key individuals to really drive that company may be in a more difficult position when it comes to identifying individuals and potentially losing those individuals in some of the situations we've discussed. Olga, moving ahead, I wanted to talk about whether some of the analysis on the ethical considerations of internal investigations has changed in light of these trends.
Sure. When we conduct these investigations and we sit down with somebody for an interview, the first question that often comes out from that person is, are you my lawyer, and if not, should I get a lawyer? It's very important very early on to sit across the table from the person who's being interviewed and tell them that, no, I'm conducting an investigation on behalf of the company. I'm the company's lawyer, and any information that you share with me will be shared with the company, and it's the company's choice to share that information with the government, with any third party, or to use it in any way that it deems fit. I think that in light of what's happening and the increased scrutiny on individuals, these types of issues are even more highlighted. I think that folks are going to be more inclined, as Peter has said previously, to seek their own counsel. And I think lawyers conducting internal investigations need to be extra careful to never give an impression that whatever they're saying or whatever they're asking of this individual is being construed as legal advice, or giving any impression to that individual that they're that individual's lawyer. Again, all of this increases costs, all of this prolongs the investigation because folks, again, I don't think are going to be as upfront and forthcoming as in years past. But I think that this is a cautionary development for folks like us, for lawyers like us who do these investigations and who talk to employees, officers, directors, any individuals that are potentially involved in the corporate world, to not give them an impression that that we're their lawyers and be extra careful to advise them that any information is actually likely going to be shared with the government, a regulator, or any other third party.
Following up on that, a lot of what Olga was just referring to, we all traditionally know as the Upjohn Warning, which has been called the equivalent of a corporate Miranda warning. Peter, do you think that in light of the trends we're seeing, there needs to be a revision to the Upjohn Warning, or just, whether not legally required, just kind of a practical pointer? Should more information be provided in that warning than what we've typically seen?
I do. I think you have to be very, very clear to the individual, and I know a lot of people cringe about this because, again, it's just increasing the cost, but I do believe you have an obligation in conducting the investigation to make it abundantly clear to the individual who's being interviewed and perhaps his lawyer that anything that he says will be shared with the government.
And just on a final point, I think something we always have to keep in mind is, the role of privilege in our internal investigations. And the Yates memo takes pains almost to say that it is not requiring a waiver of privilege. But of course, the language that states that all relevant facts need to be disclosed in order to get cooperation begs that question. Jeff, did you have, what are your thoughts on whether or not the Yates memo is requiring a greater level of waiver than before, or if it is not requiring waiver?
I'm not sure it changes the dynamic much. Remember, most of the underlying facts investigated are probably not privileged to begin with because they're not advice of counsel, internal types of things that would be subject to a privilege. Most of the facts about companies' conduct are not subject to a privilege. What has been the case for a long time is if you do a report with analysis and findings on liability and you submit it to the government, you probably waive the privilege in other contexts. I don't think that's changed.
Yeah, I think one area that should remain privileged are the discussions among counsel for the company with the board or with the special committee as to the decision, first of all, as to the decision as to disclose, and secondly, as to what is going to be disclosed. I think those discussions should remain privileged.
And just to add one more thing on this issue, is there a requirement to waive the privilege? No, I don't think that there's a requirement, and I think that you're right about the fact that the Yates memo explicitly addresses this point. However, if you do waive the privilege, are you going to potentially get more cooperation credit? I think so, and I think that that's just the reality of it. So while there's no affirmative obligation to waive it, I think that if you are, it's going to go into the government's decision matrix of how much credit to award you and whether your actions should mitigate the potential sanction. If you're turning over memos and you're telling the government here what our key people are and this is why we think they're important, and turning over the key issues that came out of those memos and are assisting the government in its investigation and tailoring the issues and saving potential resources that it would otherwise have to invest, yeah, I think that the reality is that you're potentially going to get more credit.
And let me add, I think generally, at least in my experience with the FCPA, you would certainly turn over the findings of fact you made, but you probably wouldn't turn over, for the most part, your internal legal analyses, and that's what Peter was alluding to. And just one last point, which is there was a question before of small versus large companies, and just to come back to that in closing, there is some indication in the pilot memo in FCPA that you wouldn't expect as much out of a smaller company in terms of the thoroughness of the investigation as you would a bigger company. That's nice. Again, my experience with outside accounting and audit firms are that they have unfortunately required a degree of thoroughness for smaller companies in investigations and intended to drive that train. So while I'd like to say smaller firms are under a less thorough standard of investigative thoroughness, I'm not sure that's reality today. Thank you.
We've gotten some questions, one of which is, does refusal to cooperate in the internal investigation jeopardize an executive's right to indemnification, including paying the cost of an executive's own counsel under Delaware law or corporate charter/bylaws? There are Delaware, Maryland, and some other states have very broad advancement and indemnification provisions. That's not to say that companies can't stiff them, and by that I mean they may decide that even under provisions that would otherwise provide advancement, they may decide they're not going to pay. There's recently a case involving Goldman Sachs where one of their managing directors is suing because Goldman Sachs did not advance fees and is not indemnifying the managing director for those that have already been incurred. I do think that you run the risk that you get sued, but a company may decide, look, what's in our best interest is for you to cooperate. You don't want to cooperate, that's great. We're not going to advance your fees and expenses.
Another question that's come in, which is worse, cooperating and throwing your employees under the bus or making a knowing election not to fully cooperate? Sounds like a lose-lose. Jeff, is it a lose-lose? Is it that black and white?
I think, look, these are, in the end, informed business decisions. And I think there are a whole range of facts. What that decisional analysis I provide is designed to do is help you focus on the different issues involved in it. And, it's hard. These are tough decisions for companies to make. In my experience, again, the thing that's been the driver in the FCPA has been the huge size of the fine. Even if you get a discount, the huge size of the fine, might tend to push you to not disclose if you really have that option. And by the way, you don't throw your employees under the bus in the consequence. Remember, not disclosing doesn't mean you don't do an investigation. So the way I look at it, if you do a reasonable investigation, you take remedial actions, and you don't disclose it, I think that's a very reasonable approach, and I don't necessarily view that as a lose-lose. And by the way, you can protect your individual employees in the process.
We've had another question come in with respect to the privilege discussion. Is a potential solution to agree to what is referred to as a limited waiver? Olga, have you ever been in a situation where you've asked for a limited waiver, and if so, have you had success with that, or does it just create problems down the road of opening up a waiver issue?
I think it can be done, but it has to be done very carefully, and I think that there needs to be open discussion with the government in advance and some memorialization of those discussions to really define what the waiver entails. I think it's a dangerous thing, and I think it can have a snowball effect if it's not done correctly. But if it is crucial to the company's claim or defense, or if it's really going to put the company in the best light or provide a tangible benefit down the road, then it should be done. Again, taking certain precautions to making sure that everybody's on the same page, what specifically is being waived, the fact that it's not an open waiver, that it's only related to either a specific document or a specific issue. At the end of the day, does it open up the possibility for a fight down the road? Yes. But again, it's not an easy determination, and it really is case specific, but it could play to the company's benefit.
And I've heard that, where I hear this more often than not is a situation where the government is trying to refute what the lawyer for the witness that is not cooperating, the executive that's not cooperating, who says he was only acting on the advice of the internal lawyers. And the government wants to talk to the internal lawyers and better understand what were the circumstances under which the advice was being given.
Another participant asked, what about wrongful termination actions if someone declines to cooperate in internal investigations? Company fires, and does the employee then have the opportunity to sue? And I think this was exactly the case in Gilman, where they chose not to cooperate, and the court the suit was actually teed up as seeking to get their employee benefits back, and the court came out and said that the company had taken reasonable steps in asking for the interview, and thus when they didn't comply, it was reasonable to terminate them. And so there was no ability for them to come back with a wrongful termination suit.
Right. Well, they can, anybody can pay their money and take their chances, but the bottom line is the Second Circuit was saying it was entirely reasonable to terminate them based on their lack of cooperation. Okay, let's wrap it up.
With that, I think we will conclude for today. Thank you, everyone, for your time and your attention. I would like to mention that the slides from today's presentation will be distributed by Sutherland. And for those of you who missed it, the CLE code is Yates, Y-A-T-E-S. If you have any further questions, please feel free to contact any of the attorneys. Our contact information is on the final slide, and we appreciate your participation with us today.
Thanks so much.